the strongest jurisdiction that you really want, if you can have it, and if it meets the client's needs, is going offshore to, for example, a Cook Islands offshore asset protection trust. And that's simply just because the Cook Islands statutorily do not recognize any U.S. court orders or judgments. They're just going to tell you to go pound sand. And the U.S. followed after the Cook Islands. So the Cook Islands created this in the 80s, I believe. Yeah, I believe it was actually in the 80s. And then after that, the U.S. follows suit about 10 years later. Okay. So you have half the amount of case law on this. And then we're already seeing a lot of high-profile domestic asset protection trusts crumble now and being pierced. And the reason of that is just a hallmark of the U.S. system compared to the hallmark of asset protection.
When you hallmark, go
explain that term. Sort of just like what is the essence of it. So the essence or hallmark of any asset protection system is just saying we're not going to recognize that court order judgment. Now compare this to the hallmark of the U.S. court system. We have the full faith and credit clause of the Constitution. You can't run from judgments in the U.S. And so you can't have any U.S. court order taken to another state and say, sorry, we're not going to recognize it. It's just not how anything in the U.S. works. Okay. Now you compare this to why it's important to look at the possibility of going offshore is you can take that court order to the Cook Islands and a Cook Island trustee, and they're just going to say, thank you, we don't care.
Right.
And that's the power of going offshore, is being able to look at a court order and a judgment and say, we don't care if you can collect $2 million, we're not going to transition the assets back and give it to you. It's just a stronger form of protection. And so when you go through the analysis of domestic versus offshore planning through like ECCM, you're going to get pros and cons for both. To go purely foreign is going to be as effective as heck. I mean, statutorily non-recognition of court orders, very effective, 5 out of 5 stars. If you start breaking it down to cost, maintenance, and control, all of a sudden your costs are going to go sky high just to go out purely offshore. You're looking going from, $1,500 in annual maintenance fees to $5,000 to even $10,000 a year. That's really expensive. And then you're looking at potentially loss of control, because then you have to go into the offshore trustee, which then we build around with that of having trust protectors who look over the trustee, so you don't have a rogue trustee saying, what are they doing with my assets? Right. And then you're going to lose control of that also.